6 for there to be such a disregard of the terms of our interrogatories. My lords, we are opposed to this application for review, and we rely on the depositions in the affidavit in opposition and the statement of case that we filed. My lords, under CI 16, Rule 54, the court may review any decision made or given by it on any of the following grounds: exceptional circumstances which have resulted in miscarriage of justice, or discovery of new and important matter or evidence which, after the exercise of due diligence, was not within the applicant's knowledge or could not have been produced by him at the time when the decision was given. My lords, the submissions that we have heard today have not canvassed any new matter or exceptional circumstances for which this court's review jurisdiction should be exercised. My lords, what we have rather heard was a rehashing of the arguments that was before the court when the decision was taken on the 19th of January. In this regard, my lords, may I humbly read the decision of Adade GSC in the case of Mechanical Lloyd Assembly Plant versus Nati, reported in 1987-88, 2 Ghana Law Report 598, Supreme Court. My lords, with your kind permission, it says, let me say at once that for all I know, virtually every judgment on this earth arrived at as a result of evidence gathered from several sources can be criticized. A Privy Council judgment put in the hands of any lawyer along with the evidence grounding it can be criticized in the same way as a High Court judgment can be. A person who has lost a case will almost instinctively feel that the judgment must be wrong. And why not? If he had won, the decision will be right. So if he lost, how could the court be right? But the mere fact that a judgment can be criticized is no ground for asking that it should be reviewed. A review jurisdiction is a special jurisdiction to be exercised in the exceptional circumstances. It is not an appellate jurisdiction. It is a kind of jurisdiction held in reserve to be prayed in aid in the exceptional situation where a fundamental and basic error may have inadvertently been committed by the court, which error must have occasioned a gross miscarriage of justice. The review jurisdiction is not intended as a try-on by a party after losing an appeal, nor as an automatic step from an appeal. Neither is it meant to be resorted to as an emotional reaction to an unfavorable judgment. My lords, it's my submission that the arguments we have heard today by the applicant is just an emotional reaction to an unfavorable judgment quoting Adade, and therefore this application should be dismissed. That's my submission.
My lords, we are opposed to this application, and we rely on the depositions in our affidavit in opposition filed on the 25th of January 2021 and our statement of case filed on the same day. My lords, we wish to make the point from the very beginning that the court grounded its dismissal of the application for interrogatories on 3 key points, and not, as counsel for the petitioner has sought to suggest, on 1 point. The court raised the issue of relevancy, the issue of lack of matters in controversy, and then made the point, the 3rd point, that CI 99 establishes strict timelines, and therefore the application will not, therefore Order 22 will not apply in this circumstance. So the first myth that has to be blown away is that the court never ever said or implied that CI 47 had been repealed or will never apply in a petition, in an election petition. This is a gross misconstruction.
He said Order 22. Order 22.
Yes, Order 22 or CI 40. I mean, Lord, I'm saying that my submission is that this interpretation is a gross misconstruction and an impermissible gloss that counsel seeks to put on what the court said. Now, my lords, my second point here is counsel has raised the issue of relevancy. Now, the issue of relevancy goes to the issues to be determined in the trial. And if your lordships look at the issues to be determined in trial as set out, it becomes very apparent that these matters that were raised in the interrogatories are not really germane to the issues to be determined in trial. The issues are: 1, whether or not the petition discloses any reasonable course of action; 2, whether or not, based on the data contained in the declaration of the first respondent and the second respondent as president-elect, no candidate obtained more than 50% of the valid votes, as required by Article 63(3) of the Constitution. 3, whether or not the second respondent still met Article 63(3) of the 1992 Constitution threshold by the exclusion or inclusion of Techiman South constituency presidential election results. 4, whether or not the declaration by first respondent dated 9 December 2020 of the results of the presidential elections conducted on 7 December 2020 was in violation of Article 63(3) of the Constitution. And finally, whether or not the alleged vote padding and other errors complained of by the petitioner affected the outcome of the presidential election. My lords, it is my submission that it is more than obvious that the issues sought in the interrogatories, are not really relevant in the determination of these matters. Secondly, my lord, the court's second reason was that the issues sought in the interrogatories were not related to issues in controversy. That is, the issues joined by the pleadings. It is then only after these 2 fundamental reasons that the court makes the observation that in any case, or in addition, CI 99 prescribes strict timelines. Therefore, the court will not apply Order 23. In this circumstance, what is meant by this circumstance? That is, all the issues that have been looked at or discussed in the ruling. We all know that when you are doing interpretation, you do not just pick one sentence or paragraph out of a whole construction and make a meal out of it, as counsel for applicant seeks to do. My lords, let me then make the point that the reference to the Mona case, my lord, is misconceived and involves a deliberate attempt to put an impermissible spin on the Mona case for purposes of this application. In the Mona case, what the court held was that rule in CI 74 that sought to take away the right of review was unconstitutional. Now, in order that the petitioner can suggest the relevance of the Mona case to the present application, he seeks to suggest that the CR 99 has impliedly repealed the right to interrogatories. That is the whole point. Now, if the court, as I've demonstrated, has nowhere said that CI 99 has repealed or amended the right to apply for interrogatories under Order 22, the whole argument of the relevance of the Mona decision falls flat. It crumbles, my lord. Now, similarly, my lords, we believe that it is important to recognize the point that every application that is brought for interrogatories must be decided on its own terms based on the general principles governing the grant of application for interrogatories. Therefore, it is again misconceived for counsel to suggest that because in 2013 an application for interrogatories were granted, automatically the Supreme Court is bound any time an application for interrogatories is brought in an election petition to grant it. My lord, that is poor logic.
We are used to our jargons. Maybe you can say that it's misconceived.
Very well, my lord.
Yeah, we are used to our jargons. We are
my lord,
other professions.
My lord,
yeah.
My lord is well taken.
Yeah.
I withdraw that point. But my lord, I believe that it is completely misconceived to suggest that because in 2013 we were granted interrogatories, in this case we should be granted interrogatories. Again, the lords, my lords, I want to refer to the Nigerian decisions. My lords, and all the other decisions that were referred to in paragraphs 23, 25, and 26 or so of the statement of case. My lords, in all those decisions, the court, exercising its discretion, held that in the particular situation, the applicant was entitled to the grant of interrogatories, and therefore held that the refusal was wrong. So, my God, lords, one cannot just cite those examples to determine that the refusal in this particular case was wrong. Again, the applicant has the burden of demonstrating to the court how the refusal in this particular case was wrong. And furthermore, he has an obligation to demonstrate, one, that the error was a fundamental error. True, that fundamental error occasioned them a gross miscarriage of justice. And it's our submission that the applicant has failed to demonstrate these very basic conditions to grant a review. In the circumstances, my lords, we pray that the application be dismissed as completely unmeritorious. Pray accordingly.
My lords. Yes, respectfully.
Because I think as regards the first respondent's opposition to the motion, he just cited the off-putted
which made reference to the mechanical Lloyd case. Because, my lords, I think it's important to...
Yeah, what is the case?
This is Hannah Asi, number 2. Hannah Asi, number 2, and Gihok Refrigeration. 2007 to 2008.
Yeah.
Supreme Court of Ghana Law Reports at page 16, which actually, it considers all the line of cases.
I think it was referred to.
My lord, it was not in our statement of case.
Yeah, it is.
My lord, I think you're referring to the draft of our supplement to the statement of case, which your lordships have thrown out of the window.
I wouldn't like Mr. Kutampao to use certain words in the court of law, so please, without
with respect, I didn't say that disrespectfully. I use that word out of the window in a light-hearted manner, but if it's offensive, I take it back. I use that word just in a sort of light-hearted manner of, so I take that back as not reflecting perhaps the circumstances here. So I was simply drawing attention to the fact that Hannah Asi is not in our statement of case. That's all. Yeah.
It was in the proposed
and I would also respectfully, in relation to the point that counsel for the second respondent made about the exercise of discretionary power, I would also respectfully refer your lordship to another authority of the Supreme Court. In the case TDC and Musa against Atta Bafo, TDC and Musa against Atta Bafo. That is 2005 to 2006, Supreme Court of Ghana Law Reports, page 121. And in particular, His Lordship Dr. Barnes' words at pages 152 to 3. Now, my lords, you also heard counsel for the second respondent suggest that the issues that you have set down are the basis on which relevancy must be determined. With all respect, those issues that you set down were actually set down after the hearing of the application for leave. After. So, unless my learned friend was anticipating that those were the issues that would be set down, respectfully, those, at the time of our application for leave, those issues had not been set down, and therefore it's illegitimate for him to claim that it is in terms of that application for leave that he's arguing. And finally, my lords, the reference that is consistently being made to strict timelines under CI 99, respectfully, my lords, we are saying that what the application sought to do was actually to facilitate those timelines, especially in terms of a judgment by March being complied with, because we're not waiting for things to be done in cross-examination and so on. And my lord, if you wanted to be literal and mechanical about the meaning of those timelines, we would draw your lordship's attention to one very simple example. The timelines put filing and serving of process of the petition in January, for instance. January is stated in CI 99, Rule 69C4. It says January, filing and service. Are your lordships going to say that because we filed on the 30th of December and the process was served by the 31st of December, therefore we do not comply with the strict timelines in CI 99? Are your lordships going to say that? I mean, my lord, with respect, this very simple way of trying to interpret Rule 69C4 would lead to gross absurdity if we were to follow it.
All rise.
Order, please, order.
Oh, yes, sir.